client spans a multitude of technologies and industry areas, including comics and movies, fine arts, restaurants, and disease treatments. He has published numerous articles and has taught at several universities, including Fudan University in Shanghai, Columbia Business School, Seton Hall Law School, and the University of Chicago Law School and the Booth School of Business. Without further ado, it's my pleasure to cede the floor to David.
Let's see if I can get myself online here in one piece. And hello, everybody. Questions are strongly encouraged. If I don't get to them during the talk, I'm happy to answer them later offline. We're going to be talking not about IP for lawyers and all the fine points of patent, trademark, copyright, and trade secret, but about what a business person, a student, a professor, a VC, finance needs to know in order to take advantage of this. I sometimes call this CEO IP, the IP that the chief executive officer and other board level and C-suite people need to know, or pressure point IP, named after a type of karate which tries to hit things that are particularly important, particularly sensitive, particularly useful. We'll start with trying to explain why this does matter for the C-suite, the board, the finance person, VC, private equity, angel, whatever level, for the entrepreneur, of course. What is IP? How do you manage the IP itself and the strategy for the IP? How to analyze the value for business, how to summarize and present your IP strategy, both internally and to people you're seeking funds from, or mergers or acquisitions or joint ventures or other deals, and how to ask the important hard questions so as to be able to do diligence in a New York minute, which will be one of your handouts. Let me see if we can ask polling question number 1, trying to find out what sort of people are in the audience. Adam, can you trigger that?
Yep, I just deployed that question. So again, for everyone on the call, you should see that in front of you. Question is, are you a student, a faculty, an entrepreneur, working at a startup or small company? Are you in the finance field, angel investing, VC, private equity, or an employee at a larger, more established company? So we're getting some responses coming in now, and I'll be happy to share those. We're about 60% voted, so just a few more seconds for folks to tally their answers, and I'll be happy to share those out. All right, so looks like we have just 2% that are students. We have 59%, so the bulk of our attendees today that are entrepreneurs working in a startup environment or with a small company. 9% in finance, and 30% that are employees at larger, more established companies.
Excellent, thank you. And we wanted to get one more perspective on who you are in the audience. So we're going to deploy the second polling question.
Great, yep, and this one is gauging attendees' main education or interest. Options here are science, engineering, software, math, biotech, humanities, business, finance, economics, medicine or medical field, or law. And those results are coming in. Just a couple more seconds to collect all of those, and I'll share those out as well. All right, so of our respondents to the second question, we have a majority, 55%, that are in business, finance, or economics, 25% in kind of the STEM field, science, engineering, software, math, biotech, 10% in law, 8% in the humanities, and 2% in medical fields.
Great. The theory of all this is it's universal. So in a sense, it doesn't matter. But I tend to talk about startups and VCs as sort of the easiest perspective to understand it from, and startups that are engineering related, technology in the sense of applied sciences, but this applies to luxury goods companies, emoji companies, comic book companies, music companies, poets. The teaching will still be useful. So we start with the notion that it's a big part of any enterprise's value. We'll call it the company for convenience. It may be Ben and Jerry's B Corp, trying to do good. It may be a lot of different things, but that increasingly companies' value is not made up of the land they own or the factories and equipment they own, but the intellectual property. And what do you as a non-lawyer or a non-IP lawyer need to know in this area? I try to summarize during this speech based on 5 shapes that I'll be giving you. But that most new and interesting companies especially are sometimes even more than this 84% number. The best brands, the best technologies, the places with the best reputation, the most excitement, that are doing the biggest solutions to the biggest problems. And you think about 1,000 or 500 years ago, wealth was land, Sherwood Forest, Robin Hood, and so on and so forth. 50 and 100 years ago, wealth was factories and equipment. The General Motors factory turning out bombers for World War II. But now it's ideas, intangibles, intellectual property that marks the really interesting and important companies, both in America and around the world. There's, of course, a big risk in IP if you don't really understand it. And part of it is it's a risk that someone might copy you. What are you going to do about that? If you're doing something that's valuable and important, people are going to want to commoditize you and do the same thing. And if you're doing something interesting and important, people are going to say, oh, you're copying me. Maybe so-called patent trolls, maybe universities that have patents in the area, maybe competitors that want a piece of the action. Or if you're really disrupting the competitors, you're going to get attacked and they're going to want to kill you and shut you down and stop you from disrupting them. So the question of getting attacked as well as doing the attacking, plaintiff and defendant side, wildly important. You need IP strategy so you can create a good menu of options. What should we do in these situations? And then within the menu, pick which one you're going to follow. And that picking is not a one-time fire and forget and it just goes. It's a constant steering and changing as new events unfold and figuring out what should the R&D strategy, the marketing strategy, the business strategy be. It's really all a business strategy from an IP perspective. Just to emphasize the risk value, intangible assets a lot harder to see than land or factories or equipment. They're invisible. They're intangible by definition. They're ideas, not things. They're not real property, land, or personal property stuff you can pick up and touch. And they don't easily fit into old form balance sheet accounting. They don't easily fit into old business school agendas. They didn't know how to care. They don't know how to deal with it. So as you build the castle to protect the treasure, it isn't the walls and moats and archers. It's much harder to design it well and design it to be strong, design it to be efficient in terms of protecting yourself. There's lots of different ways for either the new company, mid-size, large company to fail. You think about Kodak, BlackBerry, Xerox's mistakes. Even if you get everything else right in your startup, you got a good team, you got a good product, services, good prices, you're giving good value, the value can all leak away like a submarine with a window left open. You want to make sure that the IP stuff is handled right along with all the other parts of a business. I have no expertise in those. Clearly, if they're not done right, the IP won't matter. But if you succeed, you will be copied and accused of copying. Also, good IP strategy and diligence can help you spot Theranos types frauds. You look at the lousy patents and you look at the weaknesses of the technology that way. And one of the interesting equivalents is that the good diligence that a VC, an angel, private equity, merger and acquisition should do in buying you or deciding whether to finance you is the same sort of diligence you should be doing on an ongoing basis to run the company better and to get value. Whatever that VC is going to invest, you as a startup are investing much, much more of your energy and your life. You really, really want to get these things right. So what is IP business strategy? It's business strategy from an IP perspective. If you fail, it may not matter. But if you succeed, you will get copied and have plaintiff side problems. Am I going to sue those people? How am I going to discourage that copying? If I don't do something to discourage it, my premium pricing will get eroded away as I become commodified. And I'll be accused of copying. I'll have defendant side problem. People attack me on their patent, trademark, copyright, trade secret. It's an inevitable price of success in the United States and indeed the world today. You may indeed be attacked while you're still small and weak before you've succeeded well. I think of I am Dorothy, the small and meek, in responding to I am Oz, the great and terrible. You may have to, if you're particularly making a fuss and a bother about being a loud disruptor in a field, the incumbents may say, let's squish them now while they're easy to kill. Will you be ready? Intellectual property strategy is understanding and using all of the assets, the actions, the values, and attack and defense to increase your profits, increase your value, increase the chances of success. If you could somehow measure a single number of someone's IP quotient, how well are they using these assets, you would get a Gaussian normal bell-shaped distribution, which means that a lot of companies are getting C's and below, only a few are getting A's, and most people, there's a lot of room for improvement. That means that if you can move yourself up a grade or two by doing intellectual property strategy better, you're going to, by definition, be increasing both the value, valuation, and profitability of the company. When you, the entrepreneur, do something wonderful, you need profits and values in order to continue it, expand it, and bring the benefits to the customers in the world. Proper IP strategy integrates with your marketing strategy, your business strategy, your R&D, distribution, hiring, alliances, financing. It's just the same thing seen from this other perspective with additional knowledge, additional tools to make it better and more profitable, more valuable, more likely to have long-term success, as opposed to you getting disrupted or you returning to a commodity status and not having anything special to offer a price. So the 5 shapes that we're going to be talking about are a tesseract, which starts as a cube or a square, and a 6-cycle hexagon, and a 4-level pyramid, a 5x2 presentation rectangle, and a Vitruvian man 5-star figure for the diligence. Let me start with the cube or tesseract now by describing the X, Y, and Z axis of intellectual property understood for business, for entrepreneurs, for finance. The X-axis is the rights, different types of IP. The big ones are patent, trademark, copyright, and trade secret. There are other things besides that: design patents, protection for plants, chips, privacy, publicity, trade dress, artistic control. But you get the big 4, you've at least started. Of those, trademarks, trade secrets are ancient. Conan the Barbarian's dad that made his sword had a trademark hanging over his hut. I am Conan's dad. I make really good swords. Buy swords from me and not the guy next door. And he had trade secrets. Where did he get the steel, the coal? What were the mixtures? How long did he cook it for? The other 2 rights, patents and copyrights, to me need government, and they're more recent. Another way to think about these 4 is that patents are the work of engineers, trademark the work of advertising, marketing, the madmen of the world, copyrights for Soho and art and books and novels and poetry, and also software, because that's a form of writing. And trade secrets typically for things like recipes or methods, things that are hard to engineer, whereas a circuit, you can open up the device and see what it is, a chemical, you can find out what's inside that thing by doing chemical analysis. But how long did you cook the brownie for? Just which chocolates did you use? What was the temperature of the oven? These sorts of things the final product does not reveal. So recipe type information is still very appropriate for trade secret, much harder to reverse engineer for someone to figure it out. I also want to note here that patents are to protect inventors. That's their 3rd purpose in my view. They're to help protect those who help finance inventions and new ventures. That's the 2nd point. But the first most important reason we have patents is to enrich the libraries, to make sure there isn't lost knowledge because it's been kept secret. Damascus steel, Greek fire, mass production by Eli Whitney's cotton gin, a magic pill that turns water into gasoline, whatever it is, you want the knowledge published as it's created, and the way to do that is to have patents in the world. That's the X-axis. The Y-axis, the major activities: litigation, licensing, protection, and deals. The reason I emphasize litigation first is as you build your IP strategy, hopefully litigation comes last or never happens. It's expensive, it's risky, it's well worth avoiding if you possibly can, but it's critically important to be in a strong position to win it if you're stuck in it. But as you think through what am I going to do to protect, you want to be thinking, would this work in a real fight? So my silly example is that in the Errol Flynn, Douglas Fairbanks Jr. movies where they get into the sword fights, they reach above the fireplace, they pull down the swords, but they're stage swords. They're, if you will, cardboard swords. You want your swords to be real, able to be used in real fights. So you need to think through litigation, even in the hope that you're never going to be in it. You're going to build the foundation, the protection, so that it would fight well. If it'll fight well, then it will license well, because the licensing person is sitting there going, should I take a license? Should I ignore this IP? Am I better off paying? If I ignore it, will I get sued? If I get sued, will I lose? They're running through a sort of war game scenario of the litigation in terms of taking a license. Same thing for a good deal, a financing, a merger, whatever it would be. What would this IP be worth if it was really, really tested? And of course, the z-axis would be the different types of arts and sciences. I use physics, chemistry, biology, software, and design as my big four. Whatever it is, you have things like nanotech, clean tech, my beloved DNA synthesizer that had some physics, had some chemistry, had some biology, had some software, had some design elements. Sometimes these layers collapse. If you have Cartier or Van Cleef, luxury goods, there may not be new engineering or science behind that product. It may be all in the design, but often, and in some of the most interesting areas of technology, multiple sciences as well as multiple rights and multiple activities. And then to turn our cube, our 4x4x4 IP space cube, into a tesseract and add the fourth dimension, time. Time is always changing things. It's very hard to make predictions, especially about the future. Whatever you guess, you may be wrong, but you can make better versus worse guesses. IP in particular is the law of change. Real estate law, you can look back hundreds of years. Many other forms of law have evolved for a long time. But by definition, someone who's getting patents and trademarks and copyrights and trade secrets is doing something new. They're disrupting the old, and they in turn will also be disrupted. And so you have to build in the change that an iPhone brings along, not just in computing, but in things like Uber, Lyft, Airbnb, many other businesses. And the more you disrupt, the more important you are, the bigger the change, the more the existing incumbents will want to come after you with their IP. So both they'll copy you, they'll accuse you of copying. Very, very important. So a couple of further reasons to justify why you should care and why this is important to you. You'd have a startup. It is, by some high-level objective measure, worth $300 million. But IBM, Google, Apple, Microsoft, Bayer, Genentech, Exxon, Ford, General Motors, whoever it is, sues you. And after 2 or 3 years of exhausting litigation, you sell out for $100 million. Huge loss of value. You don't want that to happen. As you get the initial money from friends and family, also known as friends, families, and fools, then angels, then VCs, then private equity, then perhaps an initial public offering or merger and acquisition, the diligence can get ever more careful and thoughtful. I find that particularly in the merger and acquisition stage, the company that's buying you really knows the space well, is really going to look at the IP carefully. You're really going to get good probing hard questions, but you never know. There's going to be VCs, there's going to be private equity, there may be occasional angels that start asking a good hard question. But even more important, those same good hard questions help you manage the startup all along its path. So the diligence questions and the management questions are, to me, equal to each other. And if you keep asking them, and if the VC keeps asking them not only as it makes a decision to invest, but asks them of portfolio questions, many of which struggle and fail despite careful selection, they may be able to increase their odds from, say, 1 out of 10 to 2 out of 10. And that would be huge. So in many of these financial events, you need good IP and IP strategy in order to justify why is it worth 300, not 100 million, or whatever that number might be. Again, coming back to litigation, these fights are, from my point of view, close to inevitable if you are otherwise successful. Litigation will be the strongest test of your IP and its strategy. Will the jury, will the trial judge, will the appeal judges find for you or against you? And it could be an attack side, could be a defense side, copying or accused of copying. You think about the Google, Waymo, Uber trade secrets case, which I believe ended up settling for $245 million. Self-driving cars are going to be a big deal. You can slow down a competitor, you could really get in their way, you could stop them, you can charge them a lot of money, different things can happen. If you're ready, it's going to go better than if you're not ready. Certainly one precaution on the trade secret box is be careful of who you hire and how you hire them. When you get a patent, that patent may or may not be valid. It may be so narrow that it's not infringed. It may be improved upon, so you need a license from other people or cross-licensing. Weak diligence, which I've seen sadly in a lot of angel and VC situations. Oh, we have 6 patents in 5 countries, check, IP handled. Or we've had an scientist look at this and they say it's great technology. In my view, that doesn't tell you whether the validity could fail if attacked, if there were mistakes in getting the rights in patent prosecution, if there's prior art that could be really important and kill or narrow the patents, or make them, whether there could be an issue of freedom to operate or right to use, FTO, RTU, or the frequent abbreviations. These are, again, the defendant's side issues. Whether there are alternative solutions now or rapidly coming forward that makes your solution unimportant or will soon make it unimportant. And of course, whether 5 patents in 6 countries doesn't tell you anything about whether there's strengths or weaknesses across copyright, trademark, and trade secret. So you want to be ready to fight across all of those dimensions. IP strategy also helps you, particularly as a company rather than an academic curiosity-driven research. You want to solve things that will be big, important client problems and needs. It's important that you know what's already been done, what others are working on now. You may be able to jump ahead to an important thing that other people are all striving towards, and you're going to end up controlling a piece of IP that everyone's going to need from you. Or you may be able to see everyone's going this way. If I go off this way, I'm going into blue water or white space where there's nothing else going on. And if I can, instead of going through the mountain pass, go over and around it, find a whole new route to solving the problem. Again, only knowing what's out there will let you make better choices and not reinvent the wheel. Airbnb instead of a better hotel might be an example of an alternative, or perhaps iPhone compared to prior phones. You want to make a good menu of choices. These are the things we should pursue in our product development and our research. And then within that good menu, this is the one we're going to follow. These are the 2 we're going to follow. How to pick the path within a good menu. And of course, there's always going to be a need to decide to pivot or persevere, keep going as things get tough, as failure occurs. And this, again, always going to happen. The future unfolds unexpectedly. But by knowing what's out there, you can make much better choices. If I have to cross a minefield, I sure as heck want to map, even if it's perfect. Before I cross the street, I want to look both ways twice, not 30 times and get paralyzed, but not blindfolded either. For your sales and marketing strategy, IP strategy can help as well. Customers usually have a lot of choices. You need to help persuade and explain why you're the best, quicker, faster, cheaper, that you're different, that you're the best choice under the circumstances. And by mapping and landscaping what's out there in your field, you'll be able to explain not only to the VC, not only to the joint venture or the big licensing alliance, but why is it to the customer? Is it worth your effort, their financing? Do you have a sustainable competitive advantage that are going to make people come to you? It turns out that's also an IP question. One of the things I love as a person who spent a lot of time litigating these rights is the judo of turning an actual enemy into a friend, taking the potential of a fight and turning it into a mutual advantage. Anytime you can find a way to do that with the disrupted old competitors, with marketing channels, with a hub and spoke cross licensing, you've got something, you license it out to different people, they license back improvements, you license those back out, everyone keeps getting better. I believe the CD-ROM field worked like that. If you invent a brand new special battery or a terrific hydrogen storage company, maybe they want to work together in an alliance because they're going to be replacing the old oil and gas companies. And notice, for example, Elon Musk open licensing of certain of his lithium battery technology in order to get critical mass and grow. Again, who's going to be interested in this? What's a fair price for it? Are there rights I need back because I would otherwise be an infringer or exposed to claims? By mapping and having a strategy, it lets you identify who to seek out, how to persuade them to sign deals, how to make those deals better, how to explain to investors and the next company you're talking to why each deal added value to your company. So with all of these issues and complexities and moving parts, what do you do? I hope I'm persuading you to buy into the idea that IP strategy is helpful, it's needed, it's essential. And the next shape we'll give is a 6 cycle of IP management summarized in 2 slides. But it's a legal team, the business team, the collaboration between them, the budget to make sure that the IP efforts are not too big and not too small, but Goldilocks just right. Mapping what you have, sometimes called an IP audit, inventory, and then mapping what the relevant competitors, suppliers, customers, academics around the world are doing that might be important for you. Trying to make sure that you're continually watching like the radar at an airport. The map of IP is not like a geological map or even a street map. It's like a traffic map, a weather map, a battle map. Things are constantly in motion, and you have to be mapping often enough to appreciate that and to use that. So I would describe the 6 cycle of IP management as budget. If your total budget is $10, $1,000, $100,000, $1 million, some percentage of that, perhaps 2, 5, 10% should be devoted towards IP, and some percentage of the IP budget, a percent of a percent, towards the strategy and the command control to make sure that the rest of the IP spend is as useful as possible, and it's protecting the entire enterprise as best you can. You then want to have a team. Again, this is an idealized process. These events could occur in a different order that has legal, has business, has the relevant science, technology, or design elements within it, so that those 3 voices and 3 perspectives can be considering what should we do, what are the possibilities, how do we make the choices, and so on. The mapping, brainstorming next steps, the protection steps themselves of what you've come up with, and then using the IP to make it add value to the business. If you don't use the IP, you're just wasting money getting filings you can hang on the wall, 5 patents in 6 countries. What are you doing with them? How are they useful? How are they adding value to the business? And again, it doesn't happen once. This IP committee should be meeting quarterly, perhaps monthly in a very fast-moving business, perhaps slightly less often if it's a slower-moving business, but it should keep looking for new information, new brainstorming, new improvements. Who's going to disrupt us? How do we get ahead of that? How do we make our own improvements, our own alternatives, and keep going? Arguably, this isn't rocket science. It's much, much harder. So you need these different expertises to try and do it right, to bring together the science and the business and the intellectual property law in order to make an IP business strategy. Emphasis on team. It's very rare to have one person that can do all of this. If you find a chief intellectual property officer that has all 3 skills, treasure that person. That is wonderful. But usually you need 3, or at least 2, but you often usually 3 different perspectives and backgrounds and expertise in order to form a good IP team. And like I believe it was the Yankees, could have been a different baseball team. The secret of the team is the team. The teamwork itself is what makes it strong. You may have all the needed skills within your company, particularly if you're a larger, more established company, but often newer, smaller, even mid-sized companies don't. And you may need, even in a big company, a peer to brainstorm with for the hardest problems. You want a law person who appreciates patent, trademark, copyright, trade secret, and has done litigation and licensing and protection and deals, and has a complete 360 perspective on IP. And then different specialists will get hired to actually build that relevant part of the castle, the wall person, the moat person, the archer person, whatever, but you need an architect or control person, a strategy person, deciding what sort of castle is going to make sense. In theory, this could be the end of our thing, depending on whether or not you have questions. And a couple of slogans to leave you with. You never want to make threats or assertions you can't back up. So that's, again, part of why you build the strategy from the beginning. So if there's a necessity to say, if you don't X, we will Y, you want to make sure you can execute on that. Just a patent is not a patent strategy, much less an IP strategy. 5 patents, 6 countries, very nice, but how have it been thought through all of these different steps and aspects? And if you can possibly avoid a fight, great, but one good way to avoid them is to be ready to fight. As you walk through the bad neighborhood in New York or Chicago or elsewhere, the big guy is less likely to be attacked than the weak grandpa. You want to present a formidable target. Just to take you through some more details, there'll be some handouts that will be posted, the PDF of these slides, the worksheets that I can show you now, and this article on diligence in the New York Minute. Do we have any questions? Do I need to take myself offline to find out if we have any questions?
Nope. Yeah, so we do have a question in the queue already, and I certainly would invite all of our attendees to continue to submit those questions over the next several minutes. But yeah, we can move to that question if you'd like, David. And just
Sure.
to let our attendees know, the PDF of the slides and any worksheets, those will be shared in that post-event email. Those of you who joined us before are familiar with, so I will share those materials out after today's call. But yeah, happy to share that first question, David, if you'd like.
Sure.
All right. Oh, and we've got several more. That queue is all they needed. They're flowing in now. Okay.
Okay.
So the first.
Hard to get me to stop talking, so.
So the first question, if original insulin patent was free to the public, how can slight tweaks to the patent give pharma companies a monopoly to price hike insulin and then make another patent and continue price hikes again?
So most patents are improvement patents. Rarely is something brand new. The Wright brothers airplane patent is sort of a convenient example of a brand new patent. A lot of work was needed to get to the 747. A lot of other patents needed to be added on. A lot of other inventors had to contribute. There was a classic situation early in aviation where Glenn Curtiss invented a much better early airplane. He was using ailerons rather than warping the wings like the Wright brothers, and I think he had landing gear rather than the skids or sleds that they were using. And it got to the point where no one could make a good airplane. The Wright brothers only had the patent for the original airplane. To make a better one, they'd be infringing Glenn Curtiss's patent. Curtiss couldn't make any airplane because it would infringe the original Wright brothers patents. And the field for a while froze, expensive patent litigation, not as much innovation as there should be. You had 2 competitors that hated each other at each other's throats. And progress wasn't made, I believe, until World War I forced the issue. The United States government forced cross-licensing, and eventually the companies merged, leading to the Curtiss-Wright Company. That was the answer to each having their hands at the other's throat. You want original insulin to be improved. You need to create financial incentives for that to happen. If the improvements are baloney and original insulin is good enough, you and your friends should start an insulin company and make it and sell it and say, we sell it at half or a tenth of the price of the fancy new insulin. And if you want fancy new one, it's like buying a, Rolex or a fancy watch or a Mercedes car, but we offer plain vanilla insulin at a great price. And here it is. And there are already generic companies throughout the world that have that as their business model. And if original insulin is good enough, I would expect them to be making and selling it. It's I don't know if it's white man's privilege or University of Chicago privilege or what. When I say start a company and sell it, this is hard. I recognize it's hard. But as a matter of the economics, I understand someone could do that. Maybe you, maybe someone else. So for all of these different diseases and situations, yeah, there may be existing cures and diagnostics and devices and drugs that are pretty good. when the next bad problem comes along, I was just reading Scientific American about, I can't pronounce it, dengue fever. It's still killing huge numbers of people. Millions are getting infected with it. It's not a solved problem. And often the best way to get the problem solved is to create these financial incentives, which means high-priced drugs typically in America. There may be other and better ways of having it happen. But if you eliminate patents and patent protection and the financial incentives, you could easily imagine the world being worse, either in terms of less things getting invented or brought to market, which is often the expensive part, not just the creation, or people keeping things and using trade secrets. So you can't read about the technology and say, I understand that. Here's the next stage, either as an improvement or an alternative. I was asked one time when I was teaching in China, I think around 2005, why shouldn't I steal Windows? Bill Gates has plenty of money. I need the money more than he does. And my best answer then was, if you as an entrepreneur at the aerospace university want to start your own company and make money from it and get it funded and have, again, a good profit margin, you have to live in a legal system in a world where it's hard to steal from him and it'll be hard to steal from you. The patents get abused. One of the things I've worked on is pharmaceutical abuse of patents and the antitrust cases that come on that. It's never perfect. One of the nice things is there are class action, other lawyers looking to catch those abuses and sue on them and to try and stop them. Often the improvements are meaningful, but not always. And there certainly should be a mechanism to make the less expensive generics, even if it's only 90% as good. And then people want the premium, fine. People are happy with the base, fine. I hope that answers it, at least in part.
Great, thank you. Next question, any major differences between geographies, for instance, Europe, US, China, in regards to what you've shared?
There are absolutely differences in the implementation. That is to say, when I'm building the castle of IP protection, and castle, by the way, is a terrible metaphor. Running as fast as you can while throwing hand grenades behind you is a slightly more dynamic metaphor and closer to the truth. Castle is sort of convenient, but it's way too static. When I'm building the castle in Greenwich Village, where I am now, which is different than downtown Manhattan and Midtown, where you can put up these skyscrapers because there's this Manhattan schist strong rock. When you're building on swamp, you have to build a different type of building. So as you go into Europe, China, India, Mexico, Canada, Japan, all the different countries, you're absolutely going to want, as part of your building team, specialists in Japanese patent law, Chinese patent law, enforcement against counterfeits in China, all these different issues. But the questions, the issues, the overall outline, I can show you the handouts on these worksheets I've created to sort of describe this. These, I think, are universal, though the particular answer you'll come to will change. So you absolutely need to know that Europe says it doesn't protect computer software, but it does. And how does it do that? And how does that work? Medical devices, medical procedures, there are protection of drugs and pharmaceuticals in India. There's absolutely differences that matter. But there's a lot of it that is a world question.
Great. Next question. IP is a pricey endeavor. How do you recommend a startup with limited resources to approach this problem?
My recommendation is that you let me commit malpractice. That is to say, I suggest to you that you do it yourself. And the reason it's malpractice is you won't do it right, and you'll do it wrong, and you'll make mistakes, and I never should give you that advice. But to me, it's like that doctor in the South Pole who had appendicitis or something, and she set up the laptop and she cut it out herself and she lived. And doing surgery on yourself is not a great alternative, but it beats dying. So you can get on Google Patents and thelens.org and do some patent searching and find out what's out there and start putting together a timeline of what's the prior art, what are the alternatives, what patents could be used to attack me. You can draft and file your own provisional patent application, though again, if you can possibly shake loose some money to have a professional write it, it'll be much, much better. You can do some trademark searching, both in Google and in the Start with the United States Trademark Office. It's not hard to search the European trademark databases either, and make sure that the name you're picking for your thing is at least plausibly different than what's already out there. so that you could imagine presenting to the VC or angel or your dad, you're asking to write a $50,000 check. I can't yet afford a lawyer. Part of what I want the money for is to hire a lawyer and do some of the stuff right. But as to patent, trademark, copyright, trade secret, attack, and defense, we've already done some things. We've made sure that our software we wrote ourselves and we didn't steal. We were careful about open source. We've made sure we've got rudimentary protection of our trade secrets, both cybersecurity and physical security, and we've not hired away someone from a competitor. We're thinking about who do we need licenses from and who might take a license from us, along with who would be our first customers. We've done some trademark searching. Maybe we filed an initial trademark application. We've done some patent searching in terms of what's already out there, either as prior art, the history of the field, what's old, alternatives, so that what I'm doing no longer important because the alternative is good enough, or freedom to operate, things that could be attacked. These are the most serious threats. I'm sure a professional will find more, but it's not like we haven't looked and we haven't tried. And we've written up our technology as best we could in this massive provisional application. We have at least have a filing date, a filing. Maybe we've done a design patent. We've taken some photographs of the mock-up or done a drawing. We filed that. We've started. But at each stage, you have to bootstrap it. At each stage, there's a total budget for the company, 1,000, 10,000, 100,000, and an appropriate fraction of that needs to be spent on IP to protect the rest of it. And it is inescapably difficult and painful. The only thing I can offer you is that whatever that number is, $10, $100, $1,000, $10,000 of IP stuff, you want it spent as best as possible. And these questions will help you do that. You may be able to find a clinic at the law school that will do trademark or patent filings for you on a basis. You may find a lawyer that, your brother-in-law, and he'll do the first one, but he'll take 10% of the stock, or you'll promise to come back to him when you have money. At least try.
Great. Next question. One attendee has a business proposition for a product. Is there an inexpensive way that this person can protect this information as a do-it-yourself venture, at least until they have funding of their own?
So my favorite product is a buckyball that does hydrogen storage, magic sand that can deabsorb hydrogen, and you pour it into the tanks of cars, and then when it's given off the hydrogen, you get water as the pollution, and then you at the gas station, you pour out the old sand, pour in the new sand. At every solar or wind or every place, you're disassociating water into hydrogen and oxygen. You're storing the hydrogen safely, not like the Hindenburg. World's greatest product. Please God, somebody invent it. If I have some way of actually accomplishing this, I could file one or more patent applications on the temperatures, the pressures, the chemical makeup, how you make the magic sand, what it's made of. And it's like my levitating car in the basement. I don't have to have a working model. If I correctly describe the circuitry for levitation and it works, that's a perfectly valid patent. So there's stuff you can do. The flip side of everything I'm telling you today about the importance of IP strategy is there are certainly smart VCs and entrepreneurs that say ideas are a dime a dozen, ideas don't matter, what matters is execution. And so you don't want to forget, in filing the patents, keeping certain things trade secret, thinking about which you'll patent, which you'll secret, you don't want to forget making it happen, whatever the it is. Because you don't want to get, the IP is a big important slice, but it isn't the whole pie. But there's certainly steps you can take to try and protect the technology and the ideas of what you're doing. Copyright, if you wrote it out, would just protect someone from copying the writing. It wouldn't protect the idea. Secrecy works as long as it stays a secret. It doesn't protect against independent invention. And if your security precautions are imperfect, today's, again, they can be cybersecurity and physical security, it's very easy for things to leak. So usually a utility patent, one or more, is your best hope in an imperfect world. And again, bell curve. You're not getting a guarantee or a certainty of success. You're shifting your odds further in your favor. Another saying, if you want a guarantee, buy a refrigerator. IP strategy is not guaranteed. It's moving you to be a better chance of success than you'd otherwise have. Does that do
How
it for
important?
questions? Good.
Actually, there's still a few more. So let me know too, David,
Wonderful. Great,
when
great,
we
great.
need to
Yeah,
when we need to stop short. If you have a couple of other slides to get to, but yeah, we do have plenty more questions.
excellent. These are the optional slides. Go ahead.
All right, great. The next question: how important is it to register copyrights with the Library of Congress? This person has heard of intellectual property being stolen from there.
Registering the copyright makes the copyright lawsuit and the remedy stronger in terms of their incentives in law for registered copyrights, get attorney's fees, treble damages, statutory damages. It's a good thing to do. But the trick of copyright, it's like a mantra. It does not protect the idea. It only protects the expression of ideas. So Harry Potter ideally suited to copyright, but does not give ownership over all wizard novels. The Star Trek stories or Star Wars stories, terrifically valuable and protected by copyright, but don't protect against the next space opera. In fact, I believe there's a reported decision on George Lucas suing Battlestar Galactica, robots, good and bad guys, evil empires, all the rest of it, and losing because that was a different enough story. So you are never going to get idea protection through copyright. And you're never going to get idea protection through trademark. You may get it through trade secrets, but they can leak. You may get it through patent, though people can always invent around. Great ideas will get out there one way or another if you can get a bit ahead and make some money and then continuing to improve and build on it. Imagine if Apple had stopped with iPhone 1.0. It wasn't enough to invent a great thing. They had to keep going and keep making better versions and better generations of the product. Copyright is designed for things that are published, that are out there, that are known. So you can't expect to have idea protection in copyright. Your poem, your painting, your novel, terrific, all those things of artistic expression. Your particular piece of software can't be copied identically. But someone could say, ooh, spreadsheets, what a great idea. I'll write my own spreadsheet. Copyright gives you no protection on that. So it's very strong for some things. It's useful for a lot of things. But each of these forms of protection are not simply, here's $1 million.
Great. I had a couple of questions regarding freedom to operate. One question for a startup: when is it necessary to conduct a freedom to operate analysis?
In my cyclical version of the world, it's constantly necessary. It's necessary day one, and then 3 months in, and then 6 months in, and then, and you keep doing it. Some of that freedom to operate stuff, you say, well, listen, only patents that have been filed before I started making and selling my thing count. Yeah, but new ones get published, and God willing, you keep improving your product, so the original product might not have infringed anything as of 2019 when you introduce it, but a patent filed 6 months from now might be infringed by the improved version you did a year from now. So you want to be repeatedly, constantly looking out for what's out there. And again, in this sort of diligence in a New York Minute template or theory that I have, the 5 or 6 best questions, and I've got an article about that, and that'll be attached to your materials. I say to you as a startup, what are the 3, 5, 6 most important freedom to operate threats that are out there? What are the things that are most dangerous, most would cause you to lose sleep, most would make me worry about investing in you? And if you say there are none, I know you're not careful, or you're lying to me, or something. If you say these 3, 4, 5, 6, then I can easily search those, find other things that are related to it, see if there's something else that's even worse, get a sense of how well you're thinking about these issues, and then what are you doing about those 3 or 5? Well, this one we're studying to find out if it's invalid. This one we're changing our product to go around it. This third one we're talking about a license agreement and some sort of merger of our interests so that we can use that technology. We have a strategy to deal with each. I would want to know that information early because, again, you're going to be putting minimum 24 hours a day into your startup. It's a lot of hard work. You don't want to be doing all that if there's some obstacle out there and you don't know about it. If you know about it, you could tweak the product. You can work with them. You can do a lot of different things once you know about it. But if you don't know about it, you just hit a brick wall. Very, very painful. So that would be one of the things I would do early. Now, it'll be done better and better and with more information as your enterprise gathers size, as you're able to hire professionals who really know how to do it as you're able to get more and better information and think about what is my product exactly going to be, first approximation, second approximation, third approximation. But early on, I'd want to have some idea what are the worst freedom to operate threats for what I'm planning to do.
Great. Looks like we have time for maybe just a few more questions. So I want to try and be a bit selective here. One question came in. Do goodwill allowances from business transactions serve as accurate proxies for IP valuations? And which companies are particularly astute in their IP business strategies?
I'm a big fan of Apple, Genentech, now Microsoft, Google. Some of the other pharmaceutical companies have long been very smart about this because IP is particularly important for pharma. Biotech companies like my old Applied Biosystems, exceedingly sophisticated at this stuff. There are certainly companies out there. Goodwill was to my understanding, I am not an accountant or a tax person. What was the attempt to say, here are all the physical assets, they're worth X. Here's the stock market value of the company. We really don't understand what the gap is, so we'll call it goodwill. And to me, that represents probably at least a decent approximation of how the market values the enterprise and the goodwill. When you're not public and you don't have those easy comparisons, you're effectively sitting down with the VC or the person who's going to buy you and say, I am worth 300 million and here's why. And being able to present a good IP story and strategy and explanation should add to your power to persuade. Not different than your power to persuade someone to take a license and pay 8 or 10% rather than 2% or 0.1%, or persuade a judge jury, give me a big award, give me a small award. Again, my theme is that these questions all collapse down to the similar set of questions regardless of circumstance. So goodwill for publicly traded companies is probably where that 83% intangible assets figure, that graph that we started off with, comes from. That they can't point to any physical asset, so it must be the intangibles.
Great. We have another question regarding patents. Are patents limited to people and not companies? Companies often buy patents from employees for $1.
So patents in the United States are applied for in the individual name of the inventors, and then if you're employed by IBM, Google, Microsoft, et cetera, they're going to be, as part of your condition of your employment, assigned to the company, but you'll always see on the face of the patent the individuals who invented it. One fun way to invalidate patents is say you got the wrong inventors. This often happens with university academic patents, where the big professor puts his name on all the patents, even if he or she was not an inventor. It's one of the tricks to watch out for. I believe in foreign countries, though I am not an expert, the XYZ company can get a patent, boom, in its own name, and inventorship is less important. It's fine that the companies end up in patents. Usually, particularly as a startup, you want to look like a company, not just a collection of 3 people. And putting everything into the company name is a way of, again, reassuring the VC or angel, if we inventors create stuff, we aren't going to walk away with it. We've poured everything into the company. I think we have about 30 seconds left, Adam, and I'm going to just run through these slides in this instant, and then happy to answer more questions offline. This is the 6-cycle worksheet of representing those 6 issues to think about. This is the values in business to have a portfolio, make sure there's valid, 5 patents, 6 countries, that there's validity, there's reasonable scope, that you have freedom to operate, and that you've thought about alternatives now and the ones that are coming soon. This is a way to summarize your IP. Obviously, you can twist the 5x2 either way. Patent, trademark, copyright, trade secret, and licensing. What are you doing across attack and defense? This is the diligence in the New York Minute, which is further explaining the article. The Vitruvian Man represents sort of the 5 main issues: the 2 legs, the 2 arms, and the head. This is a thing I've come up with more recently to sort of collect each idea that you've got. This is not God's will. This is just a useful sheet. This was an earlier version at my prior law firm of the Tesseract collapsed to a 2-dimensional 4x4 matrix: patent, trademark, copyright, trade secret, as against the actions of litigation, licensing, protection, and deals. And then the diligence in the New York Minute, which in the handout, I give you a higher quality reprint of, which is sort of the big, hard to lie about questions. I'm afraid I've used up my time, though, subject to, Adam, your thought if there's other questions.
Terrific. Yeah, thank you so much for sharing this. And just a reminder to our attendees that these handouts that David just covered, those will be shared in the post-event email, which you'll get this afternoon. So I want to thank everyone for participating. Special thank you to David for sharing his expertise on this important topic. Just want to remind everyone that our programming continues next week, Tuesday, April 2nd. Also at noon Central Time, we have a webinar titled 5 Reasons Your Business Isn't Profitable and What You Can Do About It. And then on Tuesday, April 9th, also at 12 p.m., we'll host a webinar on 10 ways managers can advance their careers. And just a reminder along with that, that on that same Tuesday, April 9th, that we'll be celebrating UChicago Giving Day. And we want to invite you to join the celebration of decades, degrees, and moments that make the University of Chicago great by visiting givingday.uchicago.edu. You can also visit our careers.uchicagoalumni.org page for the most up-to-date schedule of events. Once again, thank you all and take care and have a great rest of your day. Thank you, David.
Thank you, Adam. Thank you all. Bye-bye.